Good afternoon, everyone, and welcome to Marquette University Law School's annual Hallows Lecture. My name is Joseph Kearney, and it is my privilege as Dean of the Law School to introduce both the lecture and the speaker. Let me begin by recalling briefly the individual in whose memory this lecture stands. The Honorable E. Harold Hallows served as a member of the Wisconsin Supreme Court from 1958 to 1974, concluding his tenure as Chief Justice of the court. These were dynamic years in the law. Important areas of doctrine, including aspects of constitutional law, criminal procedure, and tort law, underwent major changes in this barely more than a decade and a half. Justice Hallows played a significant role in these developments on the Wisconsin front. We claim a particular connection to him, especially because of his having served for several decades before his service on the Wisconsin Supreme Court as Professor Hallows here at Marquette University Law School. A whole generation of students took courses such as Equity and Equity 2 with Professor Hallows. This teaching was in addition to Hallows' work as a practicing lawyer. For some 20 years now, Marquette Law School has held an annual lecture in the late Chief Justice's memory. And what a great privilege it is to have join us for that purpose today the Honorable David Barron, Judge of the United States Court of Appeals for the First Circuit. Judge Barron has served on that court since 2014. Before his appointment to the bench, he spent a decade and a half on the faculty of Harvard Law School, where he served as the S. William Green Professor of Public Law. It was a place that he knew well, having graduated from Harvard Law School in 1994 and Harvard College a few years before that. He continues to teach there, even while serving on the court. Permit me to give two other pieces of Judge Barron's background before standing down. First, he clerked for two renowned judges, the late Judge Stephen Reinhart of the Ninth Circuit and Justice John Paul Stevens of the U.S. Supreme Court. Second, Judge Barron was a lawyer in the United States Department of Justice's Office of Legal Counsel, both from 1996 to 1999, and again, this time as acting head of the office in 2009 to 2010 while on leave from Harvard. The work of OLC is difficult and important. I mention this service so that you will know that in addition to his primary work now as a judge and his engagement in the academy, David Barron has been an excellent lawyer. For his, or our, Hallows Lecture, he will take up the topic, When Congress and the Commander-in-Chief Clash Over War. Please join me in welcoming the Honorable David Barron.
Well, thank you very much. I said to your dean when everyone was coming in, I used to have trouble getting people to come to class, and I certainly had trouble getting them to be on time for class, so I'm particularly pleased to see so many of you here. And of course, we're here at a time when, although it's not the precise topic I'll be talking about, issues of war and peace and presidential power obviously in the news. I'm particularly pleased to be here today because I have a bit of a legacy connection to this great university. My brother was a postdoctorate fellow in the English department at Marquette, and I came to visit him here nearly 25 years ago. It's taken me a while to get back to Milwaukee, but I am glad to have done so, and I want to thank your dean for the invitation. As he mentioned, we had the privilege of clerking together on the Supreme Court many years ago, albeit for different justices. I should have predicted Joe's future. If we could analogize the group of young lawyers who were then clerking on the court to a law faculty, Joe was definitely our dean. There was no one more enthusiastic or welcoming and no one more interested in doing something that is increasingly rare and increasingly important, which is trying to bridge differences of party and outlook to remind us of the importance of there being a shared legal culture in which respectful disagreement is possible. So in that vein, I want to carry on a conversation that my colleague on the bench, Judge Brett Kavanaugh, began with his excellent Hallows Lecture in 2016. He drew on his own service as an executive branch lawyer in the Bush administration to address 5 important separation of powers challenges, one of which concerned war powers. And I want to draw on my own experience as an executive branch lawyer in the Obama administration to describe some of the history that bears on how our constitutional system allocates war powers. And I want to do so by considering one very important but often overlooked aspect of that allocation, namely who has control over how a war is conducted once it's underway. That issue obviously has importance now, as it has ever since the attacks of 9/11. We have, since that September, been in an authorized armed conflict, as reflected in the statute that Congress passed that month, known as the Authorization to Use Military Force, and it seems likely that we'll be in that conflict for the foreseeable future. And that means that a recurring issue that arises concerns not the one that we often focus on in thinking about war powers, and that no doubt is being focused on even as I speak, who gets to declare a war or use force, but a distinct one, who gets to decide how to fight a war once it begins, with what weaponry, with what tactics, with what scope, who may be detained and how and where, with what protections, what kind of surveillance is permissible and when, what kind of interrogation, how long can it go on. All of these issues and more have been subject to constitutional contestation over the last now nearly 2 decades, sometimes resulting in face-offs in the Supreme Court, but much more often resulting in clashes between presidents and Congress. And the reason is clear. Not only is this an authorized war with no clear end, but it's a very unusual one in which the enemy is not traditional, and in fact, some people contest whether it's a war at all, and the home front is very much a potential battleground. The result is that the conduct of this war is quite likely to bump into areas in which Congress has not been at all shy about regulating, thereby setting the stage for potential clashes between the commander-in-chief and what he would like to do and what Congress has said he may do. My goal in this lecture is not to resolve such dilemmas. The privilege of being a judge making public commentary is that I'm relieved of my usual paid obligation, which is to make a decision. Instead, I just want to introduce the problem to you and describe some of the history that underlies it. I think we can find in that history some important lessons about what has enabled our system of separated powers to endure, but also some cautions about its fragility and its dependence on the wise decision-making of those who are entrusted with leading its component parts. One last point before diving in. The particular separation of powers challenge that I'm going to be talking about is a fitting one to address in a lecture that remembers the great legacy of Chief Justice Hallows. As the dean mentioned, his service as chief spanned the years 1968 to 1974, and those were critical years in the history of the battle over constitutional war powers that I will be discussing. As some of you may remember, and although I won't be focusing on those tumultuous years, it was during that time that what had largely been a passive and compliant Congress, some would even say an absent one, began slowly but surely to challenge the chief executive in his conduct of the Vietnam War. In the course of those years, the first measure to prohibit the use of combat force were enacted first in Laos and then Cambodia, and then eventually in all of Indochina. The War Powers Act was also passed in this period, and during this time, the great American historian Arthur Schlesinger both declared that we were now facing the specter of what he termed an imperial presidency, and Richard Nixon's too often underappreciated successor, Gerald Ford, would find a way to bring the Vietnam War to an end while respecting the limits on his war powers Congress had imposed, and would also declare it his intention to convince the American people that his presidency would not be an imperial one. My own interest in the subject traces back to a time before I was a judge and before I had even gone into the government, when I was a law professor. Before being a professor, I had been a young lawyer at the Office of Legal Counsel, which is a small office, often confused with the White House counsel's office, but those of us in the Justice Department insist there is a difference between those two entities. And while working there, I was exposed to issues of executive power and presidential power in particular. When I left that office, the office popped back into the news after I was teaching, and as some of you may remember, in the early years of the war on terrorism, a series of news reports came out about memos that office had issued, which took a quite sweeping view of the president's power to conduct war. In particular, those opinions suggested that the president alone had the power to decide how best to defeat the enemy, and that Congress had no right to control how he exercised those powers. And those ideas took the form of opinions which suggested that even the Torture Act was unconstitutional insofar as it got in the way of the president's power to carry out the interrogation tactics that he believed were necessary. I confess, as an academic, I was surprised that this could be the law or that history would bear out that premise, but I was also surprised to find very little scholarship addressing the questions of who does have the final say in how to conduct a war, and so I dived into the issue as a scholar and produced two very long, and I mean very long, articles that reviewed that history and tried to question the sweeping proposition that my old office had taken. But then, as life sometimes catches up with you, it turned out in 2009 I was appointed to head that office as the acting head. And that meant the questions I had written about as an academic were no longer academic. And I had to confront them myself. And as you may guess, things can sometimes look a little more challenging when they confront you for real. I knew that the issues were sure to arise. After all, those memos and the positions that the prior administration had taken about the president's power to conduct the war had been very much a subject of the campaign, and I was now working on the transition for the new president, and he had, in the campaign, made all sorts of commitments about how he would conduct the war differently than it had been conducted before. And that meant questions might arise if he chose to pursue a different approach to interrogation or detention, say closing the facilities at Guantanamo Bay, and Congress decided it had a different view of how to conduct the war. What would the new president do? Would he back down? Or would he too contend that Congress had the right to dictate the rules of engagement? Well, I had my share of those type of questions during the year and a half that I served in the Office of Legal Counsel. When I came back to being a professor, I was interested in the subject anew, but this time less to figure out what the right answer was, and more to figure out what have presidents done in our history when they have clashed with Congresses over how to conduct a war. Have they fought back? Have they backed down? Have they tried to find some way of accommodating? What has been the approach? And so what I want to do this evening is explore that topic by working through three historical examples of commanders-in-chief who have confronted that dilemma and tried to address it. Now, you'll forgive me because I've cherry-picked my commanders-in-chief, and I'm fully aware that that may make this seem like a more optimistic tale than one could otherwise choose to tell it. But I think it's important to review these three, and the reason is the three are George Washington during the Revolution, Lincoln during the Civil War, and FDR during World War II. It's not just because they were extraordinary people who really, I think, understood the separation of powers in a way that was very much, as one person said of FDR, it was stitched in his breast, but also because each of them confronted this challenge when there were real existential threats to the country. After all, during the Revolution, there was a question whether there would be a nation at all. Lincoln faced a time when the nation was threatening to be split in two, and of course World War II was the most serious threat to free societies that the world has ever known. So it was not as if they were dealing with this challenge of who gets to run a war in a circumstance where the stakes were low. The stakes could not have been higher in any of these circumstances. And yet each of them, I think, when we review the history, managed to approach the question in a way that belies the notion that the commander-in-chief simply has absolute power, or a simplistic notion that Congress alone just dictates the answer. So with that set up, let me walk through basically what are just three stories about each of these commanders-in-chief. We'll start with George Washington. This is before we have a constitution, and therefore before there truly is a United States of America like we know it now, but we did have a commander-in-chief. That was the title that the Congress of that time had given to George Washington. And the first battle he faces, a very serious battle, after a relatively successful engagement with the British in Boston, is about to take place in New York. And it's the summer of 1776, and coming into the fall of 1776, and the British have amassed a huge naval force off the coast of Long Island. And Washington is convinced that this is going to end badly for him. So he's decided that there is no percentage in trying to fight back. The aim is to get out of New York. And the question is, how do you leave? So one possibility is you do a clean retreat, no one gets hurt, the British take over New York. The other possibility is you burn New York to the ground on the way out so that when the British get there, there's nothing for them to claim. Washington debates it with his advisors, and he decides the clear, correct strategic option or tactical option is to burn New York to the ground. But rather than just do that, he sends a letter to the president of the Continental Congress, who's off in Philadelphia, to ask whether he can. And the letter says, ought we leave New York to be winter's quarters for the enemy? Now, this is a room full of lawyers, so you should recognize that as a leading question. Washington is fully expecting, I am convinced, that the answer will be, no, we ought not to leave New York as winter quarters for the enemy, but it's not the answer he gets. John Hancock consults with his fellow members of the Continental Congress, and the very next day they send a letter back to Washington telling him he is absolutely forbidden to burn New York to the ground. Washington is furious. He thinks this is one of the capital errors of the Continental Congress. He doesn't see any good reason for this conclusion, but by all accounts, he feels duty-bound to obey the order and does not burn New York to the ground. Now, as some of you may know, a fire does break out in New York, and a piece of New York does burn as Washington's troops are leaving, and the British are convinced Washington had to be behind it because any good general would actually have burnt New York to the ground. But despite all the efforts of historians over many, many centuries now to find out whether Washington was behind it, all the evidence is that he was not. Some person, Washington said, as he put it, a good, honest fellow did more for us than we were willing to do for ourselves. Okay, so this first story is Washington in a sort of different mode, the classic mode, which is he's the aggressor, all the energy's in the executive is the one that wants to take the war to the enemy, and Congress is the tempering force that restrains the commander-in-chief. And the only twist on the story is that rather than the president acting like an emperor, instead he backs down. He accommodates Congress's wishes. Okay, but the story takes a different turn because not long after this standoff in New York, the Americans' fortunes are going badly. They've got one good thing that's happened, which is they did pretty well in this earlier fight in Boston before New York was taken by the British. And during that, they had captured a British officer, but they've had a string of losses since New York. And now something even worse has happened, which is one of the top generals of the Continental Army has been captured by the British, and General Charles Lee is in British hands. Well, the Continental Congress thinks this is a chance to raise the morale of the American people by making this a cause célèbre. And what they do is they stir up a lot of sense that the British are mistreating this American general who's been captured. To keep pressing this point, they order Washington, as the commander-in-chief, to mistreat the British officer that he holds just as badly as they claim General Charles Lee is being mistreated by the British. Washington is horrified by this. It goes against all his notions of decency and fair play. He also thinks it's really stupid because it means that the people of his own troops that are captured will be mistreated. And he also thinks in the eyes of the world, which they're also trying to get to support them, this will look really bad. Nonetheless, he complies with it, and Archibald Campbell, who's the British officer, is being held, finds himself no longer getting the 20 servants that he was accorded as a captured enemy officer, no longer gets to roam freely in Reading, Massachusetts in a 6-mile radius as he otherwise had, and he finds himself put in close custody in what he describes as a dungeon. And the remarkable thing is we know that Archibald Campbell thought it was a dungeon because he writes a letter to George Washington from that dungeon. And the letter reads, "You're a dictator. You could do something about this. There's just no way to treat me," and this is my favorite part of the letter, Archibald Campbell says, "I don't even have a single servant." Okay, so Washington gets this letter, and you might think Washington would just throw it away. Instead, remarkably, Washington writes back to Archibald Campbell. And what he says is, "I do not have the powers you suppose. It's neither in my authority, nor is it my inclination to disobey the orders of the Congress. But at the same time, Washington is on the side writing to members of the Continental Congress, telling them there is no reason to be doing this. And more so, he says, you've told me to retaliate against him. It's not clear the British are actually treating General Charles Lee as badly as you say. So even under your own order, it's not clear I have to be treating him this way. And he keeps writing to the Congress, even as he's telling Campbell, my hands are tied, I must do what my Congress tells me. And over the course of many months, they work out a negotiation, and eventually John Hancock writes back to Washington and says, look, we never meant for you to treat him any worse than Lee is being treated. If you tell me Lee is being treated okay by the British, you can treat this guy fine too. And then eventually Washington convinces the Continental Congress to allow him to do a prisoner swap, and Lee is let go, the British soldiers are let go, and the controversy passes. Okay, well, the interesting thing about this is now Washington's in a very unfamiliar guise. The president, the commander-in-chief, the chief executive, is not the aggressor. He's the tempering force, and it's Congress who wants to pursue hard war. Congress is the aggressor, pushing the war on the chief executive. So first thing to see, just early in our history, this is before we have a constitution, before the phrase commander-in-chief appears in the Constitution, the model they've got is a commander-in-chief who was quite overtly respectful of the idea he was supposed to follow the orders of the Congress. They've got an idea in their mind, they know from their own lived experience, that it's not inevitable that the president will be the aggressor and Congress will be the check, just as possible that Congress will want to be the aggressor and the president will be the check. And they also know from their experience that the actual lines of authority were somewhat murky. Did Washington really listen? Was he always sort of pursuing his own way around things at the same time? Did they work out some accommodation? Was that the plan all along? Okay, fast forward now quite far into the Civil War, the next great moment of sort of existential threat to the United States. The country has split in two. Lincoln is the president. And as you know, first thing he confronts is the attack on Fort Sumter, and Congress is away. Now you might think, that's lucky, right? They can't check me. But the flip side of that is, they also can't empower me. And when you read the Constitution, it's fairly clear that there was some contemplation that the president would have to be empowered to actually wage a full-scale war. So what's Lincoln to do during this period? First issue he confronts is, when do I call Congress back? In those days, they took an extremely long recess. They weren't due back until December. The attack is in April. So he has months and months ahead of him of freedom. But he wants them back. Some people tell him, call them back right away. They could get here in a couple weeks, do a little bit if you need to in the interim, but then call them back and get them to authorize things. As it happens, as many of you know, Lincoln settles on July for their return. That gives him 80 days with no Congress in place. In those 80 days, as many of you know, he does an extraordinary amount on his own. No president has ever exercised war powers like Lincoln did on his own during that period. He suspends habeas corpus, roughly speaking from Washington all the way up to Maine. He authorizes a Navy to be called up. He authorizes regular troops to be called up. He institutes a blockade on the southern ports, which is by all understandings at the time an act of war. And there's very questionable authority for some of it and absolutely no clear authority for much of it. Why'd he wait 80 days? Well, an interesting thing, and there's some debate about this, but I'm partial to this view of it. He waits 80 days in part because it's absolutely critical to Lincoln that Congress ratify what he does in Congress's absence. That means he wants a Congress that comes back that's ready to ratify. And he faces a problem because many of the border states had no legislators who could be seated. Their terms had expired and they hadn't had the new elections for the next term. He picked the 80-day mark because under the state laws of the border states and the state he most cared about, Kentucky, that was the earliest period by which they could seat a new slate of members of Congress to sit in that Congress he hoped would come back and ratify all he had done. And in that period of time, he's monitoring very closely what the elections are going to be in Kentucky to make sure that he gets a slate that's going to be on board for Lincoln's program. And lo and behold, when they come back, he's ready for them to ratify. Very first thing that happens at that special session, first bill proposed is a bill to ratify everything Lincoln had done in those 80 days. He's told by Charles Sumner, it should take a week, no problem. Turns out, that session goes on for nearly 5 weeks, and he doesn't get the authorization or the ratification for what he'd done until the very last day of that session. Congress turns out to be very difficult to get on board, much as he thought they would be compliant. Turns out they have all kinds of different ideas about what should be done and how to do it. One of the big debates that break out is whether they can even debate things other than the war during the special session, which completely exasperates Lincoln. As it happens, though, Congress does get on board, and that Kentucky delegation in particular proves supportive of Lincoln. Okay, I say this because there's a clash coming for Lincoln, and it's now over how to fight the war. And it concerns particularly what to do about the enslaved people and how they'll be treated once they're captured. By 1862, the Congress has now been largely in the control of the radical Republicans, and they want to pursue a theory of what they call hard war, and particularly they're pushing for emancipation. Lincoln, as you know, was famously reluctant to go down that route for a long period of time. Well, the way it first comes into view for Lincoln, most dramatically, is Congress starts debating a statute known as the Second Confiscation Act, which will order him to emancipate the slaves when they're taken in the South. And the theory Congress uses is it's a wartime measure, and Congress should be able to decide how what's known as contraband, that's how they were calling the enslaved people, should be treated. This is a direct threat to the powers of the commander-in-chief. They're going to tell him how to treat the enemy directly against, apparently, his wishes. So, just to give you enough flavor of this debate, a huge fight breaks out in the Senate. And one of Lincoln's closest friends in the Senate, Orville Browning, senator from Illinois, takes the view that this has to be unconstitutional. No way Congress can tell the commander-in-chief how to treat the enemy during an ongoing war. So Browning takes that view. He's then confronted by a senator from Michigan, Jacob Howard, and I want to read you a little bit of their back and forth because I think it puts into sharp relief the nature of the constitutional debate that I'm describing. Jacob Howard says that he thinks it's absurd to say that Congress has no power to tell a president how to fight a war. And this is now Howard speaking. Should the president, as commander-in-chief, undertake an absurd and impractical expedition against the enemy, one plainly destructive of the national interest and leading to irretrievable disaster, or should he basically refuse to undertake one, or, having undertaken it, insist upon retreating before the enemy and giving over the war to the manifest prejudice of the country, or should he treacherously enter into terms of capitulation with the manifest intent to give the enemy an advantage? Would the senator rise in this seat here and insist that Congress has no power to interpose by legislation and prevent the folly and the crime? Howard said he could not imagine how Senator Browning could be willing to follow the logic of his position and, quote, exclaim, "The country is without remedy. Congress is powerless. The Constitution furnishes no means to arrest the approaching ruin. We must not travel out of the Constitution. We must submit our necks to the yoke." They really spoke quite well back then, didn't they? It is the will of the commander-in-chief, and that only in such a case is the Constitution. Orville Browning praised his adversary for, quote, meeting the question in the most direct and manly terms. They didn't always speak perfectly. But he said he did not agree. As he put it, when the army is raised, when the army is supported, when it is armed, when we are engaged in war, and it is in the field marshaled for the strife, I deny that Congress, any more than the humblest individual in the Republic, has any power to say to the president, do this or do that, march here or march there, attack that town or attack this town, advance today and retreat tomorrow. give up a city to be sacked and burned, shoot your prisoners. So the debate ends. Browning loses on the Senate. The Second Confiscation Act passes, and in it is a clause ordering, in effect, the commander-in-chief to issue an Emancipation Proclamation. So Browning has one last-ditch effort to try and convince Lincoln not to do this. And he goes and meets with Lincoln on July 13th, 1862, meets him in his office, makes the case that, as he puts it, either you sign this bill and the abolitionists run the war, or you veto the bill and you run the war. That's your choice. Browning leaves his meeting with Lincoln, who apparently didn't say much, convinced Lincoln has agreed with him. What he doesn't know is that on the very day he meets with Lincoln is when Lincoln does his famous carriage ride with the Secretary of the Navy, Gideon Welles, and it's the first time he tells anyone that he's planning on issuing his own Emancipation Proclamation. So what's happened? What's happened is Lincoln, rather than seeing what Browning thinks is an intrusion on Lincoln's authority as commander-in-chief, Lincoln begins to see as a permission slip. He starts to see, maybe Congress is with me. Maybe all my worries that I wouldn't have the country go along with me if I pursued this path were wrong. Maybe the politics now is right. And in that moment, I think very much the way Washington thought about his powers, rather than seeing it as a zero-sum game, either Congress has it or I have it, he begins to see it as a potentially shared enterprise in which the aim is to get the timing right to do something that can have support. Okay, very last example, which I think we do have time for. Your dean has been quite insistent about a 45-minute time limit, so I think we can make it. Last example has to do with FDR during World War II. The year is 1942, so we're into the actual fighting a year and some after Pearl Harbor. And the war is not going particularly well. And what's going to happen is there are two different events that are going to come together with the Supreme Court at the fulcrum of them. They're going to put these issues of who controls the conduct of war right in the lap of the Supreme Court in a way that I think, in some sense, the only time in our history it's been that directly presented, maybe with the exception of the steel seizure case. Okay, the way it gets there are two things that are happening simultaneously. That summer, as many of you know, a case comes to the Supreme Court concerning the 8 Nazi saboteurs. These are hand-picked persons, each with American ties, who Hitler chooses, and they go off in U-boats to come land on the American coast. Half of them land off the coast of Long Island, half of them land on Florida, and they come in their uniforms. They bury their uniforms in the sand when they get there, and they put on their street clothes, and they're supposed to fade in to American society and wreak havoc. They're going to blow up train stations, they'll blow up bridges, they're supposed to target Jewish department stores and blow them up too. They are, in effect, the terrorists of their day. They also turn out to be a relatively hapless group. Because they had American ties, a lot of them also had American girlfriends who they immediately start looking up when they get to the United States, and those girlfriends then turn them in, and lo and behold, they find themselves captured by the FBI fairly quickly. Roosevelt has no use for them being tried in civilian courts. He views them as an invading enemy force, and they must be tried by the military, so they're transferred from the FBI into military custody to be tried in a military commission, constructed out of rules that the president will establish. And in fact, the trial of those Nazi saboteurs occurred in an office room, which was in the suite of offices in which I served on the 5th floor of the Justice Department. So the history was quite resonant while I was working there. The important thing about this case is it tees up a question for the justices that comes up in the following way. The Supreme Court gives a cert for an emergency session to hear the petition of the saboteurs as to whether they can be tried in these military courts. And in the course of those proceedings, it becomes clear the court thinks, yes, they can be tried in military courts. There's no reason they have to be held in civilian proceedings or tried in civilian proceedings. But there is one issue that the court's a bit worried about, which is what procedures can you use to try them? And the reason the court's worried is because the statutes that create the authority of the president to establish military tribunals sets forth certain rules that you have to apply. And one that's particularly key is that in order to impose the death penalty, you need a unanimous jury. Well, the Articles of War for these, for the Articles, procedural rules that the president set up for his military commission allowed you to impose the death penalty with just a 2/3 vote. So the justices start to ask some questions of the Attorney General. You know, what do you say about this? How do you have the right to do these rules? So the Attorney General takes a pass at it and says, oh, don't worry about it so much. And the justices come back and say, no, we're kind of worried about it. What do you think about this seeming conflict? And the Attorney General says, well, President is not bound by a statute in the midst of war. I mean, you can practically, as you read the transcript, see Chief Justice Stone leap forward to say, come again, he's not bound by a statute. At which point the Attorney General says, well, I didn't mean to say that. I mean, you know, I'm sure he's kind of bound by a statute. At which point Frankfurter leaps out of his chair. What do you mean? You're saying that he can be controlled by Congress? At which point Francis Biddle, the Attorney General, basically sounds like if he could just leave, he'd be happy to do so. He manages to get through the proceeding with no clear answer to it. Either the next day or a few days later, the Supreme Court issues their judgment, and it's basically a one-line order denying the petition for habeas and says, we'll get back to you with our reasoning in October. Okay, why is this so important? Because here's what happens between that judgment in July and the opinion they issue in October. A different kind of controversy concerning the president's war powers is really coming to a head. This one has to do with FDR's power to run the economy as the commander-in-chief. And it arises because inflation is spiraling out of control. Roosevelt thought that if there was any threat to the war that was greater than the military threat that the Nazis posed and that the Japanese posed, it was inflation. He thought that we could lose the war if we could not keep inflation in check, both because of the cost of goods to run the war and because of what it would do to the morale of the American people. So he's very intent on trying to cap prices, and in particular farm prices. But he has a problem because there's a statute that seems to prevent him from capping farm prices. So he's talking with his advisors all spring, what can we do about this cap? One possibility is he simply says, you know what, I'm the commander-in-chief, this is absolutely vital, we're living in an era of total war, if I can't mobilize the people, we can't successfully fight the war, so I will exert extraordinary powers as commander-in-chief to cap prices in order to save the country. There's a lot of advisors who are horrified by this idea, think it's a very dangerous notion, and there's a debate in the executive back and forth. What's he going to do? He goes to Congress to see if they'll give him some authority. No, we won't give you any authority. So what's Roosevelt to do? Well, what Roosevelt decides to do is, in classic FDR fashion, he announces, I'm going to give a radio address on Labor Day, and you'll know what I'm going to do then. So everybody's poised for this Labor Day address. What's he going to do? Is he going to issue the executive order? All the newspapers say he's going to issue the executive order. Roosevelt knows he's not going to issue the executive order. What Roosevelt does is gives an address and says, I'm going to give you 1 month to give me the power I've requested. If you don't, I'll have to do what I can do under the statutes and the Constitution. No one knows quite what to do about it. But what happens in the Congress, and this was Roosevelt's bet, people in Congress start jumping on the floor saying, we have to give him the authority or we'll have a dictator. Too clever. And interestingly, Roosevelt knows at the same time that his lawyers have advised him, just like Washington way back when read those orders from the Continental Congress and saw that there was some give in it, more than he thought, just like Lincoln saw Congress's Second Confiscation Act as potentially empowering him, his lawyers say, you know what? Congress passed a statute recently that allows you to ration goods. And that statute allowed you to put conditions on the rations. And you could put price conditions on the rations. And in effect, through your rationing program, you'd be able to get a cap on farm prices. Roosevelt knows he has this, and they've got a whole elaborate legal opinion that he's going to rely on if he needs to, but he doesn't want to disclose it. He wants to scare them to death that they might have a dictator in hopes that they'll actually authorize him to do this. Okay, so that scene, that scene has played out on Labor Day, but now we're back to the Supreme Court, because remember I told you, they said, we'll get back to you with our opinion in October, and they haven't written it yet. But they've just witnessed this extraordinary standoff between Roosevelt, potentially claiming powers to control the entire economy, and the Congress. Here's the end of the story. Chief Justice Stone is working on the opinion, and he sends around a draft to the colleagues, and roughly speaking, he says, Houston, we have a problem. The problem is he's having trouble writing the opinion. And the reason he's having trouble writing the opinion is because those statutes that require certain procedures seem to conflict with the procedures that the president has said he's going to use in the commissions. Stone tells his colleagues, well, maybe we could just overlook it, but the problem is, if we do that, and then the people get executed, and then some who are not executed come and challenge it, it's going to be evident we overlooked a legal problem and blessed it, and now 6 people will have died. The other possibility, he says, is not so good either, because I can't quite figure out how to reconcile this statute and these rules. So Robert Jackson, who was a justice on the court at the time, sends a memo around, and he says, I got a perfect solution. Just say that it would be unconstitutional for Congress to dictate the president as to the rules he has to apply to an enemy invading force in trying them for a war crime. And because that would likely be unconstitutional, we can't read the statute to prohibit the president from choosing his own rules. Well, the other justices are horrified, and in particular Hugo Black. And his law clerk writes a memo to Black, and then Black informs the court of his displeasure with Jackson's solution. And the memo says, you cannot sign on to this, boss, because if you do, it's a green light for Roosevelt to do what he was just threatening to do in taking over the economy. If we say the president's not bound by statute, that he has control, even when Congress has told him not to fight a war a certain way, we're opening up the floodgates in an era of total war. You can't go that route. And I want to close with the way this standoff gets resolved in the court, because one, it's interesting, and two, I think it fits with the theme of the lecture. The resolution to this problem takes the form of a very unusual memo that Felix Frankfurter prepares. You know it's unusual because it's titled FF's Soliloquy. I've only been on the court 4 years. I've never gotten a memo that was titled a soliloquy. Here's what Frankfurter writes. He says, I know the men who are fighting in the fields right now. They were my students when I taught them in law school. And he says, it requires no poet's imagination to think of their reflections if the unanimous result reached by us in these cases should be expressed in the opinions which would black out agreement and result and reveal internecine conflict about the manner of stating that result. I know some of these men very, very intimately. I think I know what they would deem to be the governing canons of constitutional adjudication in a case like this. They would say something like this, but in language hardly becoming a judge's tongue. What in hell do you fellows think you are doing? Haven't we got enough of a job trying to lick the Japanese and Nazis without having you fellows on the Supreme Court dissipate the thoughts and feelings and energies of the folks at home by stirring up a nice row as to who has what power, when all of you are agreed that the president had the power to establish this commission and that the procedure under the Articles of War for courts-martial and military commissions does not apply to this case? Haven't you got any more sense than to get people by the ear on one of the favorite American pastimes, abstract constitutional discussion? Just relax and don't be too engrossed in your own interest in verbalistic conflicts, because the inroads and energy and national unity that such conflict inevitably produces is a pastime we had better postpone until peacetime. And what I want to end with is a way you could misread what Frankfurter's saying. You might misread him to be saying that in times of war, the laws fall silent. But if you read it closely, the precondition for him saying, let's not have a big fight if we ultimately agree, is that he actually says all of us agree on the lawfulness of this procedure. We have different ways of understanding how to get there. Some think it's constitutional power, some think it's statutory authority. And it's critical to bypass a resolution of this high-stakes question of who has ultimate authority and leave it for another day. And in that sense, what Frankfurter's doing there is much like what Washington was trying to do in his time and Lincoln in his day, which is find some way of resolving this short of a bald claim, it's my way or the highway, or these questions are for the president alone. Thank you.
So we have time, by Judge Barron's design and mine, to take a number of questions. If you can raise your hand, and then I will recognize you. I would describe for you how the microphone system works, but I don't know. Since we had a recent changeover in that regard. But Ryan will be able to help us. So please, any questions? Yes, I think there's a way to press a button and. Yes.
I can repeat the question too.
It seems like we live in much more complicated times than in the three examples that you quoted when the definition of war meant a hot war.
Yeah.
Wars we face today, if that's a proper definition, are cyber wars, trade wars, and acts to prevent acts of perhaps war. Can you comment perhaps on this growing complication and how it fits into restraints to engage?
Yeah, well, I think I think there's a general issue of the creeping of war language to describe many things that aren't war in any plausible constitutional sense, a trade war, drug war, et cetera. But cyber war raises a really difficult question, and it's magnified in many different areas now by the capacity to wage war by stealth. So if you think about the examples that I gave, a precondition for all of those working in the way they did was a fair degree of transparency as to what was actually happening and transparency to the American people about it. After all, Lincoln calls back Congress and says, here's what I did, and then says, I'd like you to ratify it. The issue of cyber war is, what do you do when you don't even know what they're doing? And that is a confounding problem, which I think if there is a challenge to this framework of warfighting that's endured over all this time, in which the basic idea is some check and balance and some accountability in the system, is a concern that's raised when war can happen without people knowing it's happening. And just one last piece on that. I mean, even in Lincoln's time, when you call up 75,000 troops, it's not very easy to hide that from people. So Lincoln gets a lot of credit for having been forthright, but I mean, what was the option? If you block all the ports in the South, it's not a secret that you did that, right? But there was one thing Lincoln did, which he really did do secretly, which is he had secret private people take funds and go make war contracts on the sly. And he did it because at that time, people in his administration were worried that the bureaucracy was filled with traitors. And they didn't think they could accomplish what they needed without it. Well, that secret mission, he did not disclose when he spoke to Congress in his session. It's just a reminder that, you can't have a functioning system of checks and balances without people having some knowledge of what's happening. On the flip side, everybody recognizes the need for stealth and secrecy. In fact, the covert operations that were conducted, and that when I was in the Office of Legal Counsel, we sometimes had to weigh in on, that the offices had to weigh in on over time, that's a statute that authorizes covert operations, and that sets up a process which tries to build in some mechanism of accountability for it happening, because stealth is a requirement of warfighting at the same time. So that's a very deep challenge. Last piece is just what do you do about what you might call anticipated war or conflicts where it's not a full-blown conflict. And in the last 3-4 decades, that's really been this, if there's a norm or a standard type of warfighting that's happening. Unlike the war on terror, it's these kind of humanitarian interventions which take that form. And interestingly, what's happened in many of them is that they begin with the president operating on his own without any authorization to use the force to begin with. When they drag on or go badly, you do see Congress at the back end, almost in every one of them, in the Balkans, in Somalia, coming in and passing some, in Beirut in the 80s, passing some statute to set a deadline, some restriction, and more often, almost in every instance, except for probably the Libya example this last administration, the troops end up leaving within the time frame that Congress established.
Other questions? Ed Falone.
Thank you.
Professor Falone.
Thank you. Thanks for being with us, Your Honor. I think implicit in your talk was the assertion that it's appropriate to consider the past conduct of the executive branch in interpreting their scope of constitutional power. Yeah. And I'm wondering if you would like to speak to whether your experience has been that your colleagues in the federal bench give appropriate weight to past experience when interpreting the scope of presidential power.
Yeah. Well, I haven't had occasion to really have a serious case involving presidential power where it's presented, but I had it all the time when I was working at the Office of Legal Counsel. And I know there's a lot of debate about generally how do you take account of history, and in particular, even if there's, I mean, almost everybody says you can take account of pre-constitutional history, right? That's the original intent. What do you do about post-constitutional history? Because you might just say, who cares? It's after the Constitution, so it can't possibly control. If there's one area where I think there is probably something closer to a consensus about the propriety of looking at that history, it tends to be in the area of separation of powers. And I think some of it is, at least this is a thought about why that might make sense. There's a basic problem judges have with difficult questions, which is they don't know the answer, right? It's a very serious problem. When the stakes of the question are really high, as they almost always are in serious separation of powers questions, because you're talking about the fundamental architecture of the government. That's a, you get it wrong, a statute, not good, but you get the fundamental architecture of the whole country and its organization of government wrong, you're pretty sure that's bad. So if it's uncertain, it just makes all the sense in the world that you might look, well, how has it operated over time? And it's a kind of, if it isn't broke, don't fix it mentality, which I think has a fair amount of force. Now, there's a deeper problem than that, which judges who are committed to this approach find themselves facing, which is you can't figure out what the history says. And that was very much Justice Jackson's problem in the Steele seizure case. And any of you who haven't looked at the Steele seizure case in a while, and there's no reason you should have, but if you just want to see a judge at the height of their craft writing an essay that is a legal essay but is really trying to grapple with what kind of country is this, Justice Jackson's opinion in the Steele seizure case is about as good as you could do. And what he said is very readable. He's a beautiful writer. But what he says is you look for an answer in the history, and God, it's been an awful long history. You'd think it'd be there, and you just can't find it. And in particular, you can't find it in this realm when it comes to the war powers of the president. Now, what I gain from that, and what I see in all of these actors, is a certain humility and prudence in consequence. So in the face of that deep uncertainty, don't push it. But that requires two sides not pushing it, right? Both a Congress that's willing to give a bit of slack and an executive that's willing to not push things to the nth degree. That's why in the end, as much as we have a system that's run by people. And if those people aren't up to the highest aspirations of that system, it's very hard for it to work.
I think we're going to try to squeeze in one more question, if there is one. Thought I saw another hand up. Okay, we will go back there, and we will take this as the last question.
I'll just ask, do you agree that regardless of what the issue might be and what powers the president claims he has, Congress can always just pass a law saying you can't spend money on this and thereby just stop it?
Yeah. At some ultimate level, that's probably true, but there's always the question, I'll give you the example that was often kicked around in the Office of Legal Counsel when I worked there the very first time around when I was a junior lawyer. It's very clear the president has a pardon power. Suppose you don't appropriate any money for the pen. Now, no one thinks that means the president cannot actually exercise the pardon power just because he would just disregard that. And there's some money somewhere that he could take to exercise his constitutional power. How far does one take that, right? So now it's a war. And do we take the funds from it? But I'll just end with this point about it. There's a very practical problem with using the power of the purse to regulate the president in war, and that's that you'd be cutting off funding to troops who are in harm's way in the field. And this was very much the problem that the Congress found itself facing in the midst of the Vietnam War, when there was finally a real push in Congress to try and restrict the waging of that war. The response they got from the president's supporters and the opponents of the legislation trying to restrict it was, and if you read the debate, and Bob Dole, who was the senator sort of pushing the president's position on this at the time, he keeps taunting those trying to pass the legislation by saying, well, do you mean that the troops can't fire back while we're trying to get them out? And they don't want to answer because it's politically a terrible answer and practically a terrible answer. And that dilemma sort of ran through all of the efforts to wind down that war.
So thank you. We are going to continue the conversation, but we're going to do it in a reception outside in the Zilber Forum. I want to thank all of you for being here this evening, as in many instances at other programs, but I especially want to thank David Barron for coming from Boston and giving us a wonderful Hallows Lecture. Thank you.